Away to the world across the seas, where pirates all have law degrees.
Hello, welcome back to the Canon Law. I'm Travis Anderson from Spencer Anderson. Today I thought we would do something I had promised in a previous video, and we will talk a little bit about the sovereign citizen movement. Now, people who identify with this, I would say a collection of ideas that are probably not wise to adhere to. This group of people don't like to be called sovereign citizens. They view sovereign citizen as a contradiction in terms or a dichotomy, in the sense that sovereign usually indicates somebody who is apart from and maybe individually responsible for themselves, not subject to anybody else, like a king. A king is a sovereign because nobody tells the king what to do, and a citizen meaning that they are subject to some kind of political power or government. And so they don't identify themselves as citizens who are subject to the powers of specific groups or people, in the sense that they don't subject themselves to the government because of the legal jargon, the legalese that they use, which is a product of taking words that have legal significance in various contexts, combining them together in a way that doesn't actually make sense. So the problem with the law is this. And this is where I think a lot of them go wrong. And we'll actually go through a video real quick of somebody who claims to be a constitutional lawyer who actually isn't a lawyer at all. And so one of the things that he presents is that different terms have meaning, and what a sovereign citizen, or whatever you call these people, often will do is they will take various different areas or bodies of law, different sources of law, they'll combine them incorrectly together, and they'll reach conclusions that none of those individual bodies of law reach. So in law, as an attorney, we have different sources of law, depending on what kind of law you practice. It's why lawyers specialize in various different areas of the law, because no lawyer could remember or memorize every area of law across the entire United States, or even across an entire state, because different statutes are long and lengthy, sometimes thousands of pages long, about how to understand a specific thing, like insurance law or criminal law or administrative law. And even within administrative laws, there are different administrative functions of government, and you would have to know each administrative function of government. Now, there are general principles that would allow an attorney to practice in, quote, administrative law, and maybe bounce between something like Social Security to workers' compensation, which is an area that I practice, to the Texas Workforce Commission's administrative system. But even understanding what an administrative system is can be complicated. And then, of course, you have legislative acts, you have rulemaking that's done by the executive branch, you have common law that's produced by the court decisions. All these different things work together to create the law. And so the law can be pretty complicated to navigate. It's why I think a lot of these people are reading various different sources. They're combining them together by saying, well, generally speaking, these things are all the law. And because they're all the law, we can read them together. But that's not the way it works. And so they'll often use terms that are inappropriate for various different areas of the law, and they'll substitute them for something else. So for an example of that is this. They'll often use trust language. So in estate and probate law and trust law, you have specific terms like fiduciary, you have trust and trustee. These are terms that mean something in different areas of the law that have no meaning at all in a criminal context. So the majority of these people find themselves awry of the law. And so when they find themselves somewhat on the opposite side of what's legal, usually through minor traffic infractions, because they don't want to license or insure their vehicles as they travel about throughout the public, because they believe that traveling and driving are different things. So let's go ahead and look at this particular sovereign person who is identifying as a constitutional lawyer named Rick Martin. So let's go ahead and watch a little bit of some videos about what he has to say about things.
Any law repugnant to the Constitution is no law, has no force of law, and can be ignored. Now we got to hold that in our minds. No law repugnant to the Constitution. And if we live by these rulings that you see in the Supreme Court, this has never been broken down. It's still to this day valid. Any law repugnant to the Constitution is no law, has no force of law and can be ignored. We need to start ignoring the stuff that hasn't even become law.
So that principle is not true. So things that are, quote, repugnant to the Constitution, if they're a law, you risk violating the law and incurring whatever the penalty is. Now, here's the issue with that. If you seek to change law, first of all, you can use the right to vote. That's the first thing you would do to change the law. The second thing you could do is challenge the law. You can actually engage in the conduct that the law prohibits and then go through a case where you are challenging the constitutionality of that specific statute. And so this is where one of the problems that I see with sovereign citizens, or these people who call themselves whatever they call themselves, are kind of awry, that they often don't understand that the law is complicated. And one of the amendments to the Constitution, I think they often ignore, having focused primarily on those that identify the rights that we have as United States citizens, what they do is they ignore those that actually identify how those laws work. So initially, when you're reading the Constitution, you have to pay careful attention to the separation of powers. The Constitution is federal powers, and the Constitution is a limiting document. It doesn't identify the powers of government. It limits the power of government. It identifies those rights that are relegated to individual citizens, but also to the several states. I think one of the things that I've often noticed with watching videos about these sovereign people is that they believe that they can simply just say a law is bad, as this guy did with him saying it's repugnant, and then just disregard the law. That's not how the law works. So one of the amendments to the Constitution they often ignore or don't understand is the 10th Amendment. And the 10th Amendment reads this way: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. So the federal Constitution has laws and amendment-making powers. It identifies a legislative, an executive, and a judicial branch, and it identifies the powers, the separations of those powers of those three branches of government. So again, I think they forget that states also have power. They seem to believe that a state is a fictitious entity, but it's not. And how do you know that? Well, if you read the beginning of this particular amendment, it says the powers not delegated to the United States. The United States is the federal power, but the states are the individual sovereign states that make up the United States. So the federal power only has power as the individual states grant that power to the federal government. So this is where we had problems with the Civil War, is the states said, hey, we don't like the way the federal government is running things and regulating things, so we're going to just go ahead and take our little sovereign butts and bounce. So that's what happened. Now let's look again at another video from this gentleman.
I don't go anywhere without this. This is my traffic book right here. And if you read down below, public servant officer, it pretty much says to him, when a cop pulls me over, you're losing potato chips. But when a cop pulls me over, the first thing I do is I ask him, what's your emergency and how may I assist you? And he's going to ask for my driver's license and insurance or whatever. And I said, well, before we go there, I need you to fill this out. And I take that sheet of paper out of there and hand it to him. Before we can go any further, you need to fill this out.
Now this is dumb, because what is your emergency and how may I help you? Well, emergency vehicles is an emergent event. And so emergency is going to be defined at the beginning of any body of statutes or rules. And so emergency doesn't mean that somebody's been hurt or is dying or something like that. Emergency can also be that somebody's engaged in an infraction of the law. And so that becomes an emergent situation. It's something that arises. So this idea of emergency requires whatever it is that he thinks it is kind of silly, because emergencies and other terms are defined in law.
As he reads this, it already puts him on notice that I'm not playing games with him.
Once again, requesting that an officer fill out a paperwork before you present them with the required instruments of your driver's license, proof of insurance, and registration of your vehicle is just going to land you in jail. These are antagonistic ideas that are being promulgated that are bad ideas. Some kind of paperwork that has some kind of what you think magic language in it is not going to solve the day or solve the problem.
Then you open up the book.
Okay, now this sounds really tough. It's like, oh, I'm so tough because I have this paper that puts him on notice that I'm not playing games. I don't think a lot of police officers who read a paper like this are going to really care, because remember, they're the ones that have the badge, the gun, and the lawful ability to arrest. So no matter what you think, the police officers, no matter how much resistance you put, the police officers will win that argument.
And that is so poignant. And here's the case I won against Harris County. Harris County, I always take my name out because I'm not going to give my name.
Now this is a claim that he won some suit, and it's actually convoluted because it looks like there was some kind of criminal action that was dismissed, and then subsequently he filed a lawsuit. Now I'm not saying he didn't successfully pursue a lawsuit, but we'll talk about this guy's history a little bit and how these things actually work out.
Until you can give me what's called, and police always call it, it's RAS. What's your RAS? And they automatically assume I'm a cop because I'm using their lingo.
I thought this was funny because RAS, reasonable articulable suspicion, is a term that's often used by police officers to identify, it's by the Supreme Court, and it's them borrowing language from the Supreme Court. It's actually not a police term specifically, but you have to have the ability to articulate why you pulled somebody over, why you're interacting with them. That the Supreme Court doesn't always require that you tell the person that you're interacting with that thing. So that's just false.
And what RAS stands for, reasonable articulable suspicion that I've committed a crime.
Now, the fact that if a police officer approaches you and has the belief that you have committed a crime, the RAS would have to be, the reasonable articulable suspicion is something that you would present to a judge in order to identify whether there's probable cause for the interaction that led to an arrest. That's what they're going to ask for. And they're going to ask for the facts and circumstance. So if I see somebody driving down the road and I'm a peace officer and they have a broken tail light, that's my reasonable articulable suspicion, is that they're driving on the road with a broken tail light. So they have a defect in their car, and the Texas Transportation Code allows them, or the criminal code, or the statutes of whatever they are, allow them to pull somebody over because of that infraction.
Okay, you don't have that? Okay, what's your SAF? Single articulable fact.
Now again here, you don't have that is a funny thing that he actually identifies, that you don't have that. Who's to say that a cop, one, has to give you that, and two, if they don't give you that, or that they don't have it. So I guess he's assuming that cops, just when they're pulling people over, will stare at you blankly when you use these magical buzzwords that are typically cop lingo. The same thing is with a single articulable fact. You have a broken taillight and I'm pulling you over.
Well, you don't have that either? Okay, you've just basically said that there's no reason to pull me over.
No, that's also nonsense. That because they don't answer your inane questions doesn't mean that they don't have a justification for pulling you over.
Because you haven't seen a crime. Okay, here's the case I won against Harris County. You can see the stamps and date, and they ended up buying me a brand new Porsche 911 Turbo all-wheel drive convertible. With them pulling me over and letting me spend a night in jail.
Here's the thing that he doesn't identify. He doesn't actually identify the facts of the case. But these documents are very vague and ambiguous. He doesn't tell you what happened. So simply because you pull somebody over and you go stand before the judge, and the judge may dismiss the charges. Judges dismiss cases for any number of reasons. They don't just dismiss cases because you're right. They sometimes dismiss cases because of the cop not showing up, or because his body cam wasn't working that day, or he doesn't remember the you being pulled over, or whatever. I mean, there's a lot of reasons. I actually was involved in a traffic case where I went down for a friend of mine to take care of a ticket for him, and there was a bunch of lawyers and a bunch of people there doing the same thing. And the judge actually called, a number of people by name, had him come and approach the bench, and he said, okay, it's your lucky day. I'm dismissing all these cases. And I found out later that the reason he had dismissed all those cases is because the body cam footage for all those cases was unavailable and the officer was unavailable to testify. That doesn't mean you didn't didn't speed or change lanes without signaling or any of those other things, it doesn't mean you're right. It doesn't mean that the cop was wrong in pulling you over. It just means they're not going to pursue with the case because they just don't have enough evidence to proceed.
So, and here's the lawsuit, and I've got these for everybody to see, and you can see that it's all put together, and there it is, signed by the DA and stamped, showing they lost the case.
No, it doesn't. I don't know what that shows because he doesn't actually identify what that shows. Having stamps and signatures on things, a document that's filed with the court can receive a stamp. A prosecutor can sign something because it's a notice of appearance. So having signatures and stamps on things doesn't mean anything.
And they lost it, and they paid
And
you
I
what?
sued them.
And what did you win?
$250,000 for a night in jail.
Now, what he's talking about is that there could have been some problem with the arresting officer. So obviously cops make mistakes, and when they do make mistakes and they incarcerate people even for temporary periods of time, that does give rise to a civil case. You have a constitutional case where your rights have been infringed by the state or by law enforcement. And when that happens, they do end up having to pay money damages. And there are specific amounts of money damages depending on the type of case and how things happened. He doesn't go into any details. So just thinking that because you got arrested, challenge the case with a bunch of this legal jargon nonsense doesn't mean you're going to get $250,000. So I think he's being a little disingenuous by not being specific as to the facts.
And then Supreme Court says no license necessary to drive an automobile public highways. Now these...
This case is nonsense. This is actually not what the case says, that there's no license necessary to drive on public highways. This case actually has to do with the fact that the case that he's citing, if it's the correct one that I'm thinking of, has to do with the fact that a person doesn't need a license to travel in between different states. So typically, if I have an 18-wheeler, and I drive from Nevada into Utah, by driving from Nevada into Utah, Utah can't require that I have a separate license to enter Utah with my goods and services, pay a special tax or fine or fee or something like that. So the Supreme Court's more talking about these kinds of situations, which is what they would have power over, rather than identifying the specific rules of the road. So there is no such thing as a federal driver's license in the sense that individual citizens can't apply for and receive permission to drive in a state within a state's sovereign borders, because those are the sovereign state's rules. So the Supreme Court's rulings or the Department of Transportation for the federal government, those rules don't trump the state's ability to regulate and govern their own land and their own roads. So it's just nonsense. So requiring each individual citizen to have a license to operate a very large, dangerous motor vehicle is very reasonable because these vehicles can be harmful, and cause catastrophic injuries and even deaths.
These are all documented. So what this is called stare decisis, okay? We're running a case that's already been won in the Supreme Court.
It's actually called stare decisis, and stare decisis means let the decision stand. And that just means that once a decision has been made by the Supreme Court in a specific case, that stands until they change their mind on it. So, or they go back and they look at the prior decision and they say, well, based on the context. So the idea that a case can't have a subsequent case that overrules the prior decision is just ignorance of the law. This happens all the time.
And they're in violation of their oath of office when they don't pay attention.
Yeah, this is not correct. That just sounds like gibberish to me.
My license plate doesn't give you, if you look at my license plate, the license plate alone says I'm not in commerce. Now, if I have a license plate like this car over here and that car over there, they all have license plates. License plates mean I'm engaged in commerce.
Here's the issue. This is the whole thing about traveling versus driving, and traveling for private purposes versus commerce. These people are completely wrong on this. This whole sovereign idea of I don't need a driver's license, I don't need to register my motor vehicle, those are nonsensical ideas. Those are not correct, and please don't believe them. Because here's the issue. Commerce is such a broadly applied principle. It's what gives the federal government the ability The Commerce Clause is what literally gives the federal government the ability to regulate almost everything that they regulate, is they say it touches commerce. The fact that cigarettes are transported across state lines, that they originate someplace and they're transported to someplace else, is what allows them to have the firearms, etc. The ATF gets its power from the Commerce Clause. Congress enacts laws based on the Commerce Clause and says, these are dangerous items, they pass across state boundaries, and because they do that, we're going to regulate them. Because otherwise, let's say that if you manufactured cigarettes and they only stayed in the state of Alabama and they never left the state of Alabama, the federal government would have no right to regulate them. But because people purchase and create something in one state and then transact it or move it across state boundaries, gives the federal government, when they choose to, the ability to regulate those things because they are touching commerce. So if you believe that by getting in your car, entering onto a public street, turning on your vehicle and driving is just traveling, you're crazy, because all a cop would have to do is ask you, do you have gasoline in your vehicle? Do you produce that fuel at home on your own? Is this fuel that you purchased? If you purchased the gasoline, and actually this gentleman later here in a few minutes actually contradicts himself because he says, I'm not engaged in commerce.
I'm not engaged in commerce.
So he says, I'm not engaged in commerce, but here's the problem.
This doesn't give them the authority to pull me over because they see that. Where do you see that I'm engaged in commerce? What gave you that suspicion that I'm engaged in commerce? You have the right to travel freely, unencumbered, and that's all in the law.
Actually, it's not in the law. So you have the right to obey the laws and to peaceably go about your business so long as you're not committing infractions. But here's the issue, is the evidence that you're engaged in commerce is simply the fact that you're operating a motor vehicle. That motor vehicle, you didn't manufacture it. In fact, he's driving a Lexus. Those things are manufactured foreign. Those are foreign cars, probably in Japan. It's the Toyota manufacturing company that creates Lexus. So Lexus is a Toyota. These things aren't manufactured in the United States, and probably certainly not in the state in which he lives. So by purchasing that vehicle and putting it on the road, he's engaged in commerce. By putting gas in that car, he's engaged in commerce. By buying fuel and oil and all the things that car needs, he's engaged in commerce. By buying tires and having to replace the tires, he's engaged in commerce. And then here in a second, he says this is an interesting little concept.
And when we look at the law books, Supreme Court has already ruled on this. And you go back to what is a license. And I want people to do their own homework. Go read the case of Murdoch versus Pennsylvania, or read the case of, Shuttlesworth versus the city of Birmingham, Alabama.
Now, both of these cases are problematic because in both of these cases, they're old cases. They're 50 or 60 years old, each one of them. But in these cases, these had to do with protesting or religious rights. So these cases were taken up by the Supreme Court because they're touching, one of them was about the Jehovah's Witnesses who are passing out pamphlets or selling pamphlets, and they believe that they had the right to regulate them under commerce, and they don't, because that's a violation of their First Amendment religious liberties. So that's what actually is the problem there. The other one is protesters who are legally and lawfully protesting, and what they were accused of is aiding and abetting protesting. So the two gentlemen that are appealing to the Supreme Court are accused of an aiding and abetting statute. So basically somebody commits a felony or misdemeanor and you help them to do it or you support them in doing it. Well, the underlying crime that was committed by the people that they were allegedly aiding and abetting, those cases were reversed and dismissed. So there was no crime, and if there's no crime, they can't be aiding and abetting a non-crime. And so he's just wrong that way too.
These are showing that you don't need a license.
Yeah, you need a license for whatever, any dangerous activity. It has nothing to do with immoral activity. This morality idea of it is nonsense. Attorneys need to be licensed because the irresponsible and ignorant practice of the law can actually cause people to get into trouble. So if you're practicing law but don't have any idea what you're doing, you can create problems. This is why lawyers can get sued, for example, for malpractice, because they're licensed. But if you're going to somebody like this who's not actually an attorney and is pretending to be one, which we'll talk about in just a second, then you can get yourself into big trouble.
A license is to do something that is immoral, that's sanctioned by the government, like a 007, license to kill. Okay, that's immoral. They need to be licensed by the state. In other words, they're protected by the state on that.
That's a Mickey Mouse nonsense definition that he came up with. It has no basis in any kind of reality. Licensing, it has to do with things that are dangerous. And typically, if you're engaged in any conduct that could cause harm to the public, the practice of medicine, the practice of law, you need to be licensed to do that.
There's nothing immoral about leaving my house to go get a gallon of milk.
No, and that has nothing to do with it. But here's the thing, too. Leaving his house to buy a gallon of milk is actually being engaged in commerce. And that's the problem. Once you leave your house for the purposes of purchasing something, buying something, browsing for something, going into a public store, going on to any kind of private business, you're engaged in commerce. And so he's actually undercut his prior argument.
I only need a license if I'm using the public property. The roadways are public, and they're paid for by the gas tax, okay? They're not paid for by traffic violations. So
Actually undercut, I don't know what point he thinks he's making there, but the fact that the roads are paid for by gas tax or fuel taxation has nothing to do with what their purpose is. The purpose is that they're paid for by a communal enterprise where people are engaged in commerce. So he's actually undercutting his exact argument by saying, I purchase gas, I purchase fuel, and that fuel pays for the public roads. That means that these roads can be regulated because they're paid for by taxation. And so you are engaged in commerce because you're purchasing the thing that generates the tax money that is used by the government to do. I mean, the whole argument is just breaks down when you actually carefully analyze it. And so people like him, they sound very confident in their absolute ignorance.
when you get into the law, this is what scares most cops, and I'm going to get to it here if the wind would stop for 1 second.
Now, this is also kind of dumb because this idea of things scare cops. Again, this whole bunch of nonsense doesn't scare the cops. It actually frustrates them and actually pisses them off. So be careful doing this kind of stuff.
This is what most cops don't like because they don't know it. It's non-emergency use of emergency vehicle.
Now, this is the really funny thing. So I want to kind of go through this, and I want you to pay careful attention to what he says, and I'll break it down for you.
Lights and sirens is a felony. Pulling me over for a traffic violation, they just committed a felony.
That's the most idiotic reading of that in the entire world, because an emergency vehicle, again, doesn't mean that you are in an ambulance chasing after somebody or a fire truck. It also means that you're in an emergency vehicle. For example, a police cruiser is an emergency vehicle. And the emergency is that the emergent activity, the emergent event is you've broken the law. So they're turning on their lights and sirens and chasing after you to accomplish their lawful purpose of policing. And so that is the emergency. That's the specific emergency that police cruisers are designed to accomplish, is to chase down people who violate, especially if they're traffic enforcement. So that's a dumb argument.
And if they don't have reasonable suspicion that I'm engaged in commerce, they're done.
Yeah, reasonable suspicion that you're engaged in commerce. Again, he's not actually even listening to what he's saying. He's making nonsense statements that don't build on each other. And again, it's his confidence that causes people to buy into this crap. It's not actually that he's correct. Now, this is a really funny thing, and I told you I'd break down a rule, and this is kind of the funny thing that he's talking about. Totally, and a great example of somebody who's completely and absolutely misstating the law.
And you're going to love this. This is out of their own law books. This is the LexisNexis. And it says under section 502.003, registration by political subdivision prohibited.
Okay, I want to specifically point out that a registration by a political subdivision. So within a state government, there are municipalities and there are political subdivisions. So a political subdivision is the state is sovereign. So the governor is sovereign over the state as the executive branch. The legislative branch has sovereignty over the power to enact laws, the executive, of course, to enforce laws, and the legislative branch to interpret laws. So those three branches of government exist in every state. Now, the political subdivisions are like a mayor who would be the chief of police in a city. So like there's Gotham City, people who are familiar with Batman, the mayor of Gotham, and then there's a commissioner. The commissioner works under the mayor. That's why Commissioner Gordon is the top cop, but he actually isn't because the mayor is his boss and can fire him. And so the mayor is the executive. So then there is a city council that works as the legislative branch. And then there's typically a municipal courts and things like that. Those are the courts of the cities and courts of the areas in which the cities are located. So what he's talking about is the state is saying these political subdivisions do not have the authority to issue their own licenses. That's all it's saying. It's not saying that a state can't issue a license.
Except as provided by subsection B.
So we'd have to go to subsection B to see what that is. But effectively, what he's saying is that the government is saying that a subdivision can't issue a license except for this one exception. And then he's going to read the exception.
A political subdivision of this state may not require an owner of a motor vehicle to register the vehicle, pay a motor vehicle registration fee, or pay occupational tax or license fee in the connection with the motor vehicle. This section does not affect the authority of a municipality to, right here, license and regulate the use of a motor vehicle for compensation.
Okay, so what does all that mean? That is literally the state executing a statute that says that an individual municipal entity, a city, so the state is saying a city can't require its own licensing and registration. So imagine if you lived in California and as you drove from San Diego to San Francisco to Los Angeles, etc., in each city, every city could issue its own driver's license. And so if you live in San Francisco, to drive in Los Angeles, you have to get registered and get a license and you have to do all that stuff over and over again. So the state is simply saying in this statute, no, only the state can issue licenses for the entire state. Individual cities within the state, so like for Texas, Houston, Dallas, Austin, etc., can't all issue their own driver's licenses. They don't have the ability to do that. What they are allowed to do is regulate something like a taxi cab service.
If I'm not engaged in compensation, being paid to go from point A to point B, I don't need a driver's license. I don't need to register my automobile. And it is an automobile.
What about Massachusetts?
All traffic codes are pretty similar because they're all federal.
That is just wrong. All traffic codes are similar because they're federal. That's just not true. That's just nonsense. So traffic codes are state specific. There are laws governing interstate travel with common carriers, but there is not, and that's talking about 18-wheelers and large vehicles that drive across interstate. Intrastate travel is licensed by the specific state in which you live. It's regulated by the specific state in which you live, and those laws can be absolutely completely different across state lines. So this is just nonsense. Don't believe this stuff. In this final clip, Rick Martin, the fake constitutional lawyer, despite being an incredible, confident, amazing, like, I know what I'm doing and I'm going to teach you how to take care of the cops and they're just going to run away screaming because you have this little piece of paper to show them. Despite all of that and all of his bluster, here's an example of him actually in court.
You're also not licensed in any other state, is that correct?
Ma'am, may I make a statement?
You may answer my question. Are you licensed in any other state to practice law?
No, I am not.
All right, you're also not licensed in this state. I am therefore holding you in contempt and asking officers to arrest you. Contempt carries with it up to 93 days and or $7,500. You are not allowed to practice law in this state. You have formally, by your own hand, told this court you were a lawyer and that you wanted to represent your client.
Ma'am, may I make a statement?
The people who agree with this ideology will often have a friend, quote friend, that they call an attorney, or an attorney in fact is what they usually call them. There's some understanding that BAR is an acronym because it's in all caps. That's one of the common things. Now, I'm planning a discussion with somebody who actually agrees with this philosophy and these ideals, and we'll have him on and he can explain some of these more detailed aspects of it. But effectively, this Rick Martin ends up being held in contempt for practicing law without a license. And here's what he says on the record.
For myself.
What is your statement? I'll give you 1 minute.
Okay. Sims versus Ahern clearly states that the practice of law is a law of common law. I was not aware that I would be here other than acting as assistants, not as her lawyer, but as assistants of counsel in this matter to help her because she does have understanding problems of the English language.
Sir, apparently you have problems with the English language.
And I love that. The judge totally takes care of the argument that he's making. So he's saying that effectively I get to help her because she doesn't quite understand the English language. And that's actually a common problem. So if we look earlier in the video when we were talking about his analysis of the various different statutes that he's reviewing, if you go through and you read those pleadings, you'll find that he actually doesn't seem to have any comprehension of what he's doing either.
This says appearance. It is for
Notice of
lawyers.
appearance.
Do not argue with me because what will happen is you'll get another 93 days and then we'll start over. So, sir, you came in here wanting to be assistants of counsel. There is no other definition. It is plain English. You can cite cases all day to me. You're entitled to a hearing. Your rights remain intact. But for today's purposes, you are under arrest for contempt of court, this court. You may be escorted out. Thank you.
So this is what happens to people who end up trying to pretend that they're attorneys or that they represent themselves as attorneys in front of the bar. You're probably going to be held in contempt. Practicing law without a license in many states is actually, it can be a high-level misdemeanor or felony. And the reason is because there's a lot at stake, similar to any licensing issue. So remember, as you look through some of this material with these people who claim these ideologies, that they're exempted from licensure, and licensure only is for, quote, immoral actions that are sanctioned by the state, which doesn't really make much sense. But those kinds of things are identifiable as the only things you have to be licensed for. Well, that doesn't make any sense because licensure is for the purposes of ensuring that a person who's engaged in a potentially hazardous activity is actually competent in performing that task, medical, legal, other transportation of hazardous material. I mean, all kinds of licenses exist. And the reason they license people is, again, so that we can ensure that the people doing these things are doing them so within the bounds of the law. Now, if you have any questions about any of these things, reach out to my firm, Spencer Anderson. The phone number here is in the description. I love talking to people, answering questions. I'm going to do a live probably in the next few days. I'll schedule a live on this channel and I'll allow people to come on and we can have a chit chat on legal issues that you have. But again, these are very interesting concepts that people have different ideas and issues in the law. And I have a friend that I'm hope to have on the channel in the future that we can kind of discuss some of these things to ferret it out. It's a very interesting idea. It's wrong. It's completely false, but it's interesting nonetheless. So again, my name is Travis Anderson. If you have any legal concerns in the state of Texas, please reach out to my firm, Spencer Anderson. Our phone number is 210-699-0004. And I look forward to helping you, and I love to help the community. So thanks, and thanks for joining us here at Canon Law. Bye.
Away to the world across the seas, where pilots all have law degrees.